In this week's Sharp Ivo Data Law series, Anna Sharp will be talking about children's data. We'll illustrate some key points with reference to two Channel 7 Melbourne programs from 2018 investigated for the alleged invasion of a child's privacy.
Community standards generally are to the effect that children's data is in a different category to adults' data. The difficult issue is, what are the standards? What's the legal framework? I'd have to say that the key legal framework to consider is the issue of fairness, and it's not fairness to the community or fairness to the content provider or whether there's public interest involved. Where children's data is concerned, what's fair to the child? Privacy is all about personal information, and that's information that identifies someone and is about them. What happens where the face on some content is blurred? Does that mean that personal information isn't being used? In the case that we're talking about, the relevant child's image was blurred, but the broadcaster had not blurred the image of the other children involved in the incident. So those who knew the other children would know the identity of the child who was the subject of the complaint. So don't assume that because you've blurred someone's image out that you don't have a privacy issue. Another issue that came up in this case was about using public information. The broadcaster argued that it had used content from a social media site and it was public information, and therefore there wasn't any ground for the privacy complaint. Putting aside the special code provisions in that case, generally speaking, the use of personal information sourced from the public domain won't necessarily preclude it from being regarded as personal information. In that case, the broadcaster had sourced the information from a Facebook site, and the investigator wasn't satisfied that on any view that was public information. In all cases, when you're looking at using or disclosing children's data, think about what platform you're using. Is it free to air? Is it a social media platform? Is it something else? In many areas, we have an overlay of privacy law with special rules. So, for example, Facebook will have its own rules, or does have its own rules, concerning the use of children's content. Any organisation that's looking at collecting, using or disclosing children's data needs to have its eyes wide open to the rules for that particular platform involved. Think about the place of use as well. In Australia, we don't have, in the Privacy Act, any special rules about children. Children are treated as all individuals are treated under privacy law. In some countries, there's special legislation. The US has special children's privacy protection laws, and in the European GDPR, there's a special article directed to the requirement for consent for the use of children's data. If the entity that's collecting, using or disclosing data says that the use was fair and was within expectations, that raises the issue about the child's ability to consent. If on a proper view there's a question about that, whether the child is 12 or 14 or 16, if there's a doubt as to whether there's an appropriate level of expectation that the child has for use, it may well be appropriate to get parents or guardians' consent to the particular data use. If children's data is involved, special care is required. And if on a proper analysis, the use is not fair, it is high risk. Think about whether or not this really is a scenario where the consent of a parent or guardian is appropriate.